Hi, thank you for joining our webinar. My name is Diana Chavez. I'm stepping in for Ariela today. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the incredible Bill Porter, a California construction lien law guru, and today's webinar topic is a contractor's, subcontractors, and a supplier's step-by-step guide to getting paid. So without further ado, I would like to introduce the fabulous William Potter.
Diana, thank you so much for that very kind introduction. Well, since we only have 20 minutes to get this done, often we will do a seminar like this and it'll take an hour or more when I do it in person, but let's just jump right into it. So if you have any questions, you can go to the webinar chat box on the right of your screen and we'll answer questions at the end, okay? If you do have some questions, don't include any personal information if you would. Thank you very much. Okay, there's a little disclaimer. What this is about is that each situation we're gonna discuss today, we're talking about the general rules that apply, but every situation can be a little bit different. There can be exceptions, but it's really important that we all understand the general rules on getting paid. The main things we're going to be discussing are the preliminary notice, the mechanics lien, the stop payment notice, and the payment bond claim, and a lawsuit to enforce all of these. Those are the steps that will be necessary to take, and we'll go into the timelines and we will reference the statutes that are in question, and they're in our California Civil Code, and you can look them up. For more information, look on the screen. The first thing we're going to talk about is the preliminary notice. This is a prerequisite to claims for mechanics liens, stop payment notices, and payment bond claims. So generally, you have to do this preliminary notice as a first step to getting paid. Subcontractors and material suppliers on a project are required to serve the preliminary notice on the owner, the direct contractor, and the construction lender, if there is one. Okay, and there's your code sections there if you want to look those up. Now, those are for subs and material suppliers. Direct contractors, in the third paragraph, those are the ones that have a contract directly with the owner. They're not required to serve a preliminary notice on the owner of the property in order to pursue a mechanics lien against the owner. But if there's a construction lender connected to the project, then the direct contractor must serve the preliminary notice on the construction lender. That's important to note. So you'll have to find out if there's a construction lender on the project for this purpose. Okay, here are the procedures and the deadlines for serving a preliminary notice. Direct contractors, subcontractors, and suppliers all must fill out and send the California preliminary notice form within 20 days after first furnishing labor, materials, or equipment to a job site. You can send it earlier, anytime probably between when you have a contract and are beginning work, or 20 days after that. The effect of the preliminary notice goes backwards in time, 20 days. So calendar for yourself sometime after you have a contract, but before you begin working or supplying materials, to send out that preliminary notice. Second paragraph notes how to serve it. Yes, you can serve it, hand serve it if you want to, but I wouldn't recommend that because you'll have difficulty proving that you did it. Instead, so you can prove that you did it, you're going to want to use registered mail, certified mail with a return receipt requested, or express mail, or overnight delivery by an express carrier like, let's say, FedEx or UPS. Make sure you have the correct address of the recipients. And note, this is something you can do yourself, like all of this, or someone at SunRay Construction Solutions can do it for you. So preliminary notices are probably something good to do in your office. But if you're going to go to a mechanics lien, a stop payment notice, or a payment bond claim, it's probably best to get professional if you're not adept at it. But nevertheless, we're going to go over all of that, and we're going to go over the deadlines in case you do it yourself, and because you would need to call SunRay in time not to miss your deadline. Okay, always make a copy of your preliminary notice, and then when you get the receipt for certified mail or any other kind of return receipt back, I usually tell people staple that to a copy of your preliminary notice. That way you can keep it, because if you're in a lawsuit later for your mechanics lien, stop payment notice, or payment bond claim, you're going to need that proof that you sent out the preliminary notice, and your return receipt is going to be your proof. Okay, important final thing on this page, the failure to serve the required notice when it's required will invalidate your claim of lien or your stop payment notice, and in most cases your payment bond claim as well. So always serve your preliminary notice if you're required to do so, meaning you're not the prime contractor generally unless there's a construction lender. And note that the late serving of the preliminary notice will invalidate the remedies here, the mechanics lien, stop payment notice, or payment bond claim, only to the extent of the lateness. So as soon as you put the preliminary notice out, let's say through certified mail, then you're protected going backwards in time 20 days. But if you forget to do it for a month or so, then like 30 days late, then when you put it in the mail, then it's still going to go backwards in time 20 days because that's the way that preliminary 20-day notices work. All right, and so be sure to do that if you're required to do that, which would certainly be when you're a subcontractor or supplier. You always have to do this, and you have to do this when you are the prime contractor and there's a construction lender on the project. Okay, so let's say you've done all your preliminary notice and everything goes fine. If you get paid, then you don't have to worry about the rest of it, but the rest of the presentation. But if you don't get paid, then you need to pay attention to these three remedies. The first is the mechanics lien. The next two are the stop payment notice and the payment bond claim. Okay, and so the mechanics lien, it is a super valuable tool for contractors, subs, and suppliers who haven't been paid. This is because the mechanics lien gives you the right to actually sell the property where you worked in order to get paid. And it's a particularly valuable remedy for subcontractors and material suppliers who usually don't have a contract with the owner of the property. They usually have a contract with the general contractor, but it allows subs and material suppliers to jump over the general contractor or a subcontractor that they had a contract with and go directly against the owner and the owner's property and sell their property even though you don't have a contract with the owner. So it's a really valuable remedy. It puts a lot of pressure on the prime contractor to get you paid, and ultimately if you don't get paid, you can sell the property in order to get paid, which is just a huge remedy and a huge leverage for subs and suppliers. Okay, it's a remedy which attaches directly to the property. And so if the property is sold by the owner sells the property with the lien attached to it, and all your remedies are still there. They're just going to be put on to the next owner. So people can't escape from the mechanics lien by selling their property. All right, so if there's a valid notice of completion or notice of cessation on the project, okay, there are rules to apply on your deadlines for recording your mechanics lien. If there's a valid notice of completion or notice of cessation recorded at the county recorder's office where the work was done, then the direct contractor is going to have 60 days after the date of the notice being recorded in which the direct contractor must record a mechanics lien. So we're talking about notice of completion or notice of cessation. Note this rule. A notice of completion is valid only if it's recorded within 15 days after actual completion of the work of improvement. And a notice of cessation can only be recorded if work on the project stops and it's not completed, it's just ceased without completion, but it has to stop for a continuous period of 30 days, then a notice of cessation can be recorded. I'll tell you this though, notices of completion and notices of cessation are very often untimely themselves, and that means they're invalid, and then if they are invalid, you would ignore them. So if somebody says, hey, there's a notice of completion, it's too late for you to record a mechanics lien, I would ignore that. And I would still record my mechanics lien because you do not know, and it's very difficult to know if a notice of completion is valid because you're not going to know if it was recorded within 15 days after actual completion until you get into the case of it. And that's something usually left to your attorney at a later time. Okay, now that was for direct contractors, plus a little additional commentary, but for subcontractors and material suppliers, the rule is if there's a valid notice of completion or a notice of cessation, then subject to a few things, and they're in these code sections here, subcontractors and suppliers may have as few as 30 days after the date of a notice of completion or notice of cessation to record their mechanics lien. So that's a really short period of time. And for subs and suppliers, you have to be really careful and watching your calendar and watching the project to make sure if there's a notice of completion or not a notice of completion. In many projects, it is required that the owner notify you that a notice of completion has been recorded. And that's where an exception lies in, but that's kind of beyond the scope of what we're talking about here. It's for a longer seminar. Anyway, though, generally, if there's a notice of completion and you're a sub or a material supplier, you want to get your mechanics lien recorded within 30 days in order to not miss a deadline. Okay, but what if there is no proper and valid notice of completion or notice of cessation? Then all parties, the rule is that all parties are going to have 90 days after actual completion of the entire work of improvement by all trades before they must record a mechanics lien. Okay, so it's 90 days after completion, but what is completion? So here's what you do. You see A, B, and C on this page. You take the earliest of those as the date of actual completion. So if there is truly actual completion, the work was all done, it's completed. Let's say it's a restaurant, they have their grand opening. They must have completed it. That's the A of the rule. Or if the work stops and the owner or the owner's agent occupies the work of improvement, subject to some minor exceptions, but if they've moved in there, probably it's been completed. Or let's say the project just stops and it stops for a continuous period of 60 days. Then you pick the earliest of these, and then 90 days later is the deadline for recording a mechanics lien. And let me say this too. It is best not to wait for the 90 days all to go by or to be close to it. Once you are done with your work and it seems as though you're not going to be paid, don't wait for the 90 days. I would say get your mechanics lien recorded right away. And you could do it yourself, but you could probably sleep better at night if you have someone like SunRay do it, who does this all the time. All right. Okay, the procedure to record a mechanics lien within the timelines I just described, which can be as early as 30 days or as late as 90 days after a project is done. You have to record the mechanics lien at the office of the county recorder in the county where the property is located. If you're in some counties, like larger counties like LA, you have to go to the division of the county recorder, generally to record it. And then you would have to check with the county recorder to see if there is a division. I know it's in LA. I don't know of any other counties that do this, okay? And it's noted, you may not know if there's a notice of completion or notice of cessation. So if you have any doubt, record your lien earlier rather than later, because you may miss a deadline, all right? Okay, and then after you record the mechanics lien, you have a deadline to file your lawsuit. And the deadline is pretty strict on mechanics lien lawsuits. You have to file your lawsuit within 90 days after you record the mechanics lien. If you don't, then the lien is going to expire and you will be called upon to release the expired lien, because it still is a cloud on the title of the property. So when you record a mechanics lien, you're going to want to let your attorney know right away, because they have to calendar out the deadline to file the lawsuit. You don't want to get anywhere close to the final day, because things happen when you try to file a lawsuit. Sometimes the lawsuit is rejected by the court for some reason and comes back, and that takes a few days. So don't go to the end. Also, this period of time is a great time for you to try to resolve things with the other party and see if you can get paid before you have to file a lawsuit and before each side is going to be paying attorney fees. Okay. The next remedy is the stop payment notice. What the stop payment notice is, it is a notice that you would send out to the one that's holding the construction funds, which is often the owner, but sometimes it's a construction lender, and money will be set aside, usually 125% of the amount of the stop payment notice, and it'll be held for you because you have sent them a stop payment notice. So stop payment notices on private projects are served on the owner or the owner's architect, if there is one. And if a lender is holding the money, then you're going to want to serve it on the manager or other responsible officer or person at the branch of the lender administering the funds. So you would go to the local office of the bank, let's say, where the funds are dispersed from, and you wouldn't serve your stop payment notice on like the headquarters of the bank in some other major city. Okay, the time periods within which you must give the stop payment notice on a private works project, they're generally the same as for recording a mechanics lien. Okay. Let me go back to where I was. Let's see, sorry about that. The stop payment notice can be used in conjunction with the mechanics lien claim or the payment bond claim, which we're going to discuss in a moment. So these remedies, the mechanics lien, the stop payment notice, and the payment bond claim are complementary, and they're not mutually exclusive. It doesn't mean you're going to be able to collect 3 times, but if you mess up in some way on the mechanics lien, well, you still have the stop payment notice to go to, and if there's a payment bond, you still have the payment bond claim to go to. So they're kind of overlapping, but in the end, you would get, if everything worked well, you would get the amount of money you are owed through one of these sources. And honestly, the pressure and the leverage that you have by virtue of these usually gets you paid before you ever have to choose between these things. And it is rare that you even end up actually going to trial on these, because someone, you know, cries uncle eventually and they pay you because you have such leverage. Okay, there's a question on bonding a stop payment notice or not bonding it. The rule is pretty simple. If there is a construction lender on the project with a construction loan, not a mortgage like a regular mortgage, but a construction loan for the construction that you're on, then you should obtain a bond from a bonding company who does construction type bonding and bond the stop payment notice. Because if you don't bond the stop payment notice when there's a construction lender, the construction lender is entitled by law to ignore the stop payment notice, and you don't want that. They won't tell you that they're going to ignore it, but they will ignore it, and you won't get paid. So find out if there is a lender on the project, and if there is, and you have a stop payment notice, get a stop payment notice bond. Okay. There are many insurance and bonding companies who can do this for you. You just need to call around, or if you have one already, whoever gives you your license bond, you might talk to them and see if they know of somebody. Okay. The procedure to give a stop payment notice, you fill out the stop payment notice form, or you have SunRay do it, and then you would serve it on the owner's, the owner or the owner's architect, and the construction lender if there is one. Again, you can use personal service, but I always recommend either express mail or registered or certified mail and that type of thing, so you're able to prove that you served it. And then again, you have to serve the branch, where you serve the manager or other responsible officer or person at the branch of the lender where the funds are actually being held. Okay, the deadline for serving a stop payment notice, if there's a notice of completion or notice of cessation, then a sub or supplier has only 30 days from the date of a notice of completion or notice of cessation, presuming it's a valid one. Remember, we had that 15 and 30-day rule a couple slides back, which is noted here. In any event, you would serve the stop payment notice within 30 days after a notice of completion or notice of cessation. So it's a pretty short period of time. Okay. And again, if there's no valid notice of completion or cessation, then you pick the earlier of A, B, or C, whether there's true actual completion or the work stops and the owner or the owner's agent occupies the work of improvement, or all the work stops by everybody for 60 days. Then you pick the earliest of those, and that will be the date of completion, and your time period for giving a stop payment notice for serving it expires 90 days after the earliest of any of those above events. Okay, and then lastly, as with all the remedies, you have to end up with a lawsuit. You can file a lawsuit anytime 10 days after you serve a stop payment notice, but no later than 90 days following the expiration of the period of time within which a stop payment notice must be served. Now that sounds kind of confusing, because you have to figure out what's the last day I could have done the stop payment notice, and then you would have 90 days. So I would say this, the better thing to do and the easier thing to do to calendar is, if you have a mechanics lien or a stop payment notice, just calendar 90 days later to file your lawsuit, and get a hold of your attorney right away so that they can jump on this. They can calculate if you have a little bit more time, but Since if you have a mechanics lien, you have to file a lawsuit anyway within 90 days. You would file in the same lawsuit the stop payment notice claim as part of that lawsuit. So I'd say calendar out 90 days after your stop payment notice is served as your lawsuit deadline. Also calendar getting a hold of your attorney at least a month before the deadline expires. Okay, the last major remedy we're going to talk about is the payment bond claim. Payment bonds are not as common on private projects. They are generally in California available on all public works projects. But again, this is a complementary remedy. It's a bond that is issued by a bond company for purposes of paying people like subcontractors and suppliers. Not generally the prime contractor, because they're the one that has to go and get the bond, and they can't make a claim on their own bond. But you can serve a payment bond notice. It's not always legally required, but if it is, as soon as you have the claim, just like a mechanics lien, just like a stop payment notice, serve it right away. But there is a special rule if you originally failed to serve the preliminary notice, and it's possible that you could make a payment bond claim, but you have to serve this payment bond notice within 15 days from a notice of completion. And if there's no notice of completion and you forgot to serve a preliminary notice, then you may have 75 days from the date of completion to serve the payment bond notice. And this is limited. You want to read the code sections that are on this page. The better thing to do, of course, is to serve a preliminary notice at the beginning, so you don't have to worry about sending out the payment bond notice. Okay. The procedure to serve it: you're going to want to serve the bond principal, that is usually the direct contractor. Okay, and use the same methods of service we did before. Best to do, I like certified mail return receipt requested, but you can use some of these other types. And then your lawsuit. If the payment bond was recorded at the county recorder, then the lawsuit against the bond surety has to be filed within 6 months after completion of the work or improvement. If the payment bond is not recorded, it can be up to 4 years, but I don't know why you would want to wait 4 years, but that's what the statute says. And if you do wait 4 years or anything near it, other issues arise, like the question of, well, all the witnesses are gone and all the evidence is stale and all that type of thing. So you don't want to get anywhere near that. And even 6 months, why would you want to not get paid within 6 months? So I would say, like the others, I'd file my lawsuit within 90 days, just like I said as with the mechanics lien and the stop payment notice. Okay, here we are, a little bit late, but I wondered if anybody had any questions. Diana?
Bill, I do not see any questions right now, Bill.
Okay, that's great. So I'll move on to the next slide, and there's a little quiz. Okay, let's look at 2 questions only. And Diana will deal with a gift if you win. So when do I need to send a California 20-day preliminary notice? Okay. You have your answers. I don't know how you select, but I will tell you the answer is A, within 20 days of first furnishing labor or materials to the project. But it could be earlier, sometime after your contract, but no later, preferably, than 20 days after you first furnish labor or materials to a project. Okay, second question. If there is a notice of completion recorded, presuming it's valid, when is the general contractor required to send a California claim of lien or mechanics lien? Okay, what is it going to be? A, B, C, or D? It is going to be B. B is 60 days from a notice of completion. If you were a subcontractor, it may only be 30 days. Keep that in mind. But the question was about the general contractor, and the answer would be B.
Yeah, Bill, and I do not see anybody answering either on the questions slot, so they didn't answer either. Nobody won. Next time.
The first one was kind of easy there, right. And because the number was in the question, so they probably felt like it wasn't that much of an achievement to answer that one. So that's fine. Diana,
this one, yeah. If anybody could just feel free to scan that QR code where you have access to very good resources in our website. You can get a deadline calculator, download a project information sheet, see the lien law rules for the state that you need or that your project is on. very useful resources that you can acquire in our website.
Good, good. And let me add, Diana, if anybody has any questions on anything that I discussed today and you wanted to email me, that would be fine too. I wouldn't mind it at all. My email is bporter@porterlaw.com. Again, bporter@porterlaw.com.
Yes, thank you, Bill. We can go to the next slide. We have a new service. You can go to our website, sunraycollections.com, or email us at getpaid@sunraycollections.com. We can help you with your collections and receivables.
Excellent.
And we have our next webinars in April 18th, 2024 at 10 a.m. Pacific time. That is for what happens after I record my lien. How do I get paid? And the next one will be how to get the bonding company to pay. That is on August 22nd at 10 a.m. Pacific time as well. Feel free to register at sunraynotice.com/education.
Excellent.
And the exciting one is the one in person. We have a seminar on September 10th at 9 a.m. Pacific time, and Bill will have the honor to present it as well, and we'll be able to meet you in person, which is a nice thing to look forward to. And this is for how to get paid faster with liens, bonds, and contracts.
Now, yeah, and this is going to be a 2-hour seminar. So we will get into a lot of detail, and you'll be able to walk away with some nice written materials, including all the forms and all kinds of things that will be very useful to you. We don't have the location yet, but stay tuned.
Definitely. Yes, we'll send emails and we'll send communication about this in the future. You can register at sunraynotice.com/seminars.
Excellent, excellent. Let's see, here we go.
And this is another QR code that you could please, if you could take a moment to review, to leave us a review on Google, we'd appreciate it. Just take your time to scan that QR code, and we'll love to see your comments.
Okay, move next slide. Should I?
Yes, okay. Yes, sir.
Thank you.
That is it for us. Thank you so much, Bill, for such a great webinar, and thank you all for all the attendees for your time.